Right. Good morning. There's so many ways that I could describe today. It is certainly historic and exciting. I've stood at this podium on a number of occasions, making major announcements about the important work done by a variety of divisions in the Office of the Attorney General, and today we announce, and it's an historic, it's a first. We announce the first case filed by the Civil Rights Division to ensure that the Office of the Attorney General is protecting Maryland's civil rights. And it's very exciting, but I'm mindful of the fact that it's announced in the context and the backdrop of egregious and harmful conduct that you will hear about this morning. So good afternoon. Thanks everyone for being here. I want to particularly thank Vicki Schultz, Executive Director of Maryland Legal Aid Society, for partnering with us, for being here today. I want to thank my team, which I'll do a little bit later during my remarks. I'm really excited to be here. As I said, this is an historic day for the Office of the Attorney General and for Maryland generally. As part of my justice and equity agendas, my top priority upon taking office as Maryland's 47th Attorney General was obtaining the authority to enforce federal, state, and local civil rights laws. I knew this office needed that authority so we could protect all Marylanders in every part of the state from discrimination in all its forms. On January 1st of this year, I launched the Civil Rights Division at the Office of the Attorney General. I want to thank the General Assembly and Governor Moore for giving us the authorities and the resources to do just that. And this morning, the division filed its first lawsuit in the Circuit Court in Wycomico County against landlord Eric Sessoms and Mount Vernon Group, LLC, to address a pattern of sexual harassment, unwanted touching, and demands to exchange sex for rent. This is an historic day, not only because it's the first in the Office of the Attorney General and for Maryland, but because our first case brings needed attention to an understudied and under-resourced gender-based issue. As you will hear today, the defendant's conduct was severe, pervasive, and humiliating to the women forced to endure his relentless advances and harassment. This case underscores the inherent power imbalance that is often at the root of sexual harassment, and is only further magnified by the power imbalance in the landlord-tenant relationship. Like a predator lying in wait, defendant Sessoms opportunistically targeted women and single mothers in financial and housing crisis. Taking advantage of their precarious situations and abusing the power he held as a landlord, he then exploited their vulnerability to make sexual demands. We have long known that women are more likely than men to experience sexual harassment in workplace settings. We now know that women and single mothers, especially those who are low income and housing insecure, more frequently experience sexual harassment in housing as well. This form of sexual harassment makes worse, if not causes, depression, anxiety, and risks of job security for victim survivors by violating the sanctity and security of their homes, a place where every person should feel safe and secure. However, housing providers lag far behind workplaces when it comes to preventing and addressing sexual harassment. In the state of Maryland, that ends today. It's our hope that this case will shed light on this pervasive and insidious problem and put landlords and housing providers on notice. You cannot sexually harass your tenants. You cannot demand sex for rent. And you cannot retaliate against tenants who rebuff your unwanted advances. I want to make and take a moment to speak directly to those who may be experiencing similar circumstances. I believe you, and I'm taking action. But first, we need to hear from you. Before I turn the podium over to my Chief Deputy, Candace McLaren-Lanham, who oversees the Civil Rights Division, to tell us more about how victims and survivors can contact us for support, I want to commend my Civil Rights
Division for their tireless work to protect and defend the rights of all Marylanders. Under the leadership of Division Chief Jonathan Smith, who you'll hear from shortly, in just 7 short months, the Civil Rights Division has already expanded to 13 professionals and has undertaken several investigations into patterns of civil rights violations. While today marks the first case brought by that division, I expect it is the first of many. My office is committed to ensuring that every Marylander has a right to equal opportunity regardless of gender, race, sexual orientation, disability, or protected status. Candace?
Good afternoon, everyone, and thank you for joining us on what is a historic day for the Office of the Attorney General and for the state of Maryland. First, I want to reiterate what the Attorney General has said about this case being important, not only because it is a first for our office, but because it is helping us bring to light those behaviors in the housing market that too often go unnoticed, unreported, and ignored. Sexual harassment, unwanted sexual advances, and sexual assault. When sexual harassment and abuse occur in the workplace, employees have the support and guidance of their human resources departments and their colleagues. There are policies and protocols in place that indicate how these behaviors are to be addressed. To the contrary, people who are sexually harassed and abused in housing do not have that same network of support, and they often do not know where to turn for help. And to make matters worse, many of those harmed by sexual harassment in housing, which, hear me, is a form of discrimination, are women and single mothers facing housing insecurity and financial crisis. And as such, they are often hesitant to come forward and report due to a lack of resources, a fear of retaliation, and a fear of simply not being believed. I want to echo Attorney General Brown's commitment to women who are sexually harassed by their landlords. We have heard you, and we are taking action. The women at the center of this case who bravely entrusted us with their harrowing stories are the reason that we are able to seek justice today against defendant Eric Sessoms and his company, Mount Vernon Group, LLC. It took great courage for these women to come forward. We see you. We thank you. We are now fighting for you and fighting with you. But we have reports that there are other women, there are additional women across the state of Maryland who have been harassed and harmed by defendant Sessoms as well. If you are one of those women, you can contact this team at a hotline that we have established just for this case. The phone number is 1-833-282-2977. Again, 1-833-282-2977. Or you can email us at mdv.sessoms@oag.state.md.us. Again, that is M as in Mary, D as in David, V as in Victor, Sessoms, SESSOMS, at oag.state.md.us. But we know that Eric Sessoms is not the only landlord to engage in the egregious sexual harassment of tenants and prospective tenants. What happened to the women in this case on the lower eastern shore of our state happens everywhere. If you are watching in Baltimore or Silver Spring, in Hagerstown or Cumberland, in Rockville or in Bladensburg, you do not have to remain silent. And while today's press conference is focused on the women and the single mothers that were targeted in this case, we are well aware that men and members of the LGBTQIA+ community are also at risk of sexual harassment in housing. If you are facing sexual harassment by your landlord, please contact our Civil Rights Division. Our office's webpage, located at marylandattorneygeneral.gov, has a link to a complaint form that you can use to report all sorts of civil rights violations. And while our office does not have the statutory authority to represent individuals, we will connect anyone who contacts us with legal resources, whether they be through our office or through one of our partner offices. But be clear, our office wants and needs to hear from those who have experienced sexual harassment in housing, because our job and our mandate is to look for patterns. When we start seeing similar complaints involving the same housing providers, that is when we can use the power and the authority of the Office of the Attorney General to take swift and decisive action. On behalf of Attorney General Brown and this office, I thank our colleagues at Legal Aid who assisted us with this investigation. Maryland Legal Aid has been fighting for equal justice across our state for more than 100 years, and we could not have reached this point in this case without their help. And I would be remiss if I did not recognize the team that has put countless hours of time and effort into this matter. Civil Rights Division Deputy Chief Rashida Ogletree-George and Assistant Attorney General Janae Fountain led this investigation. Alongside their colleagues, Assistant Attorney General Tyler Cochran, Investigator Kelsey Richards, and Paralegal Clarissa Hibler, all led by the incomparable Civil Rights Division Chief Jonathan Smith, who we are lucky to have working with us in this office. And I will now bring him forward so that he can provide you with additional details about this case.
Thank you very much. Good afternoon. Beginning as early as 2018, Eric Sessoms, acting on behalf of Mount Vernon Group, began to serve as a landlord in Wacomico, Somerset, and Worcester counties. Many of his units were in deplorable conditions, and he targeted low-income and working people. Earlier this year, the Civil Rights Division received reports from Legal Aid that over the course of the last 6 years, Sessoms, in his capacity as agent for Mount Vernon Group, engaged in a persistent course of conduct that subjected women, renters, and prospective renters to discrimination based on their gender. This conduct included unwelcome and severe or pervasive sexual harassment. We opened an investigation into these allegations and found reasonable cause to believe that Sessoms and Mount Vernon Group engaged in the discriminatory conduct that we have alleged in our complaint. Our investigation uncovered evidence that Sessoms targeted women who were unhoused and at risk of homelessness. Sessoms required prospective tenants to disclose their personal stories with homelessness and housing insecurity. He then exploited this knowledge to identify women that he believed were vulnerable. In our complaint, we described the experience of 5 women who were subjected to Sessoms' misconduct. Their stories illustrate Sessoms' pattern of sexually harassing renters. It took great courage for these women to come forward and to take a stand against the discrimination that they experienced. Each told us of their strong belief that they needed to act to be certain that Sessoms did not harm others. We recognize and thank these women for their commitment and for their incredible bravery. Our investigation found that Sessoms rented a home to an unhoused woman. Knowing that she was having difficulty paying her rent, Sessoms told her that he would reduce her rent if she had sex with him. His request for sex in exchange for rent exploited her economic vulnerability and her need for housing. When she informed Sessoms that she was no longer willing to have sex with him, he illegally evicted her. In another case, it was reported to us that Sessoms exposed himself to a prospective tenant, grabbed her hand, and placed it on his genitals. The woman, who was then homeless, fled the scene and did not rent from the defendant. His conduct was not only traumatizing, but unnecessarily extended the length of her and her family's homelessness. In other cases, the reported harassment included suggesting that a renter perform a very specific sex act with him, proposing that another renter of a sexual encounter with Sessoms and his girlfriend, urging renters to exchange rent for sex, persistently asking renters to date him, requesting hugs and kisses, sitting uncomfortably close, and entering renters' homes without invitation and unrelated to repairs or other legitimate purposes. His conduct was not just unwelcome. It impacted the ability of these women to be safe in their homes and secure in their housing. It was harmful to the renters' well-being and in some cases resulted in renters losing housing or leaving for unstable housing situations. We look forward to resolving this case in a way that vindicates the rights of these women and protects all future tenants. We urge anyone who is subjected to harassment or discrimination by these defendants to contact the Civil Rights Division. Thank you.
Good morning. First, I want to thank you, Attorney General Brown. We appreciate your leadership, and thank you, and vision in creating a Civil Rights Division within the Office of the Attorney General as one of your top priorities. This reflects your deep understanding about the critical need to fully address and challenge legacy and emerging discrimination in our state. Discrimination that harms and holds back too many of our fellow Marylanders. And thanks to my good friend Jonathan Smith on the Civil Rights Division's first public case, and what a righteous case it is. My name is Vicki Schultz, as you heard, Executive Director of Maryland Legal Aid, the state's largest provider of free civil legal services, and protector of our most vulnerable people, including vulnerable women like the victims in this case. Maryland Legal Aid is proud to have played a key role in this matter. Our own Jamie Milliman, supervising attorney in our Lower Eastern Shore office, who's here with us today, was the first person to uncover the defendant's wrongdoing as an unlicensed landlord leasing substandard housing, primarily to women with children, struggling to make ends meet. Jamie represented the victims in their individual eviction cases, fighting to save their homes and their families. But we didn't stop there. Seeing this pattern of illegal predatory conduct by Sessoms and his associates, who were taking advantage of their tenants, single women with children, and violating Maryland's landlord-tenant and consumer protection laws, Maryland Legal Aid, led by Jamie and Lee Ogburn, our advocacy director for appellate and impact litigation, took action. We filed a series of affirmative lawsuits against Sessoms, culminating in lucrative settlements for our clients, and more importantly, peace of mind that they would no longer be subject to the defendant's illegal conduct. But we couldn't stop there, and our team didn't stop. Concerned about potential discrimination and knowing that the Attorney General had just established a new Civil Rights Division, we reached out to Jonathan and his colleagues. They were interested and eager to partner with us. In close collaboration with the Civil Rights team, we identified the horrific sexual harassment that underpinned the economic and consumer protection violations that we were addressing. We worked in parallel to address all the harms perpetrated by Sessoms and his associates. And today, we are standing side by side with the Attorney General's Civil Rights Division and the Attorney General himself, a terrific example of successful government nonprofit partnership that can deliver real results and real justice for our communities. Indeed, this is just one example. Maryland Legal Aid is committed to a continuing partnership with the Civil Rights Division, including staffing tables at community-based clinics and expungement fairs, and helping to identify other discrimination in jobs and housing. We're also working together to address the unique civil rights needs of Maryland's too often ignored rural populations. And we're just getting started. At Maryland Legal Aid, for more than 100 years, civil rights has been at the core of what we do. We believe every person deserves to be treated fairly and with dignity and justice, regardless of their economic circumstances. However, even in one of the richest states in the country, we know that we fall short, especially of these goals, especially for Marylanders with low incomes and those who live in communities of color. Our communities do not enjoy equal access to justice, despite the law's promise of equal protection. But what they do have is champions, like Maryland Legal Aid and Maryland's Office of the Attorney General. Together, we're committed to making real strides toward that fundamental process and progress and promise. Congratulations again to all our attorneys and to yours at the Office of the Attorney General, and to you, Attorney General Brown. We thank you.
Okay, we'll open it up for questions. Yes?
If someone calls the hotline and they're experiencing a situation like this, is there any way for them to get emergency housing until this is resolved?
I'm gonna let probably particularly Vicki and even Jonathan speak to that, but I do wanna highlight that, speaking up and speaking out, knowing that we in the Office of the Attorney General are here, we listen, we believe you, so as Candace outlined, whether phone or email, reach out to us so that we can provide you or connect you to the resources you need, particularly if you're in an emergency situation. That's your question. We'll have others that can speak more specifically, but also to enable us to take a look, to see where there are patterns, so we can bring action against that defendant. And like this case does, it sends a signal across the state of Maryland that sexual harassment in the landlord-tenant context and in any context is unacceptable. We will identify you with our network of partners. We will investigate you. We will bring enforcement actions, and we will seek to remove you from being a landlord or housing provider in the state of Maryland, as well as the other relief that we will seek on behalf of those who you victimize. Vicki or anyone else want to speak specifically to this?
Go ahead.
I want to rapidly turn it over to Vicki to talk about the resources of legal aid and other providers across the state. The Office of the Attorney General, as was described earlier, our office is set up to address patterns and practices of violations, and we're not equipped to take emergency relief, although I certainly would never rule it out under the right circumstances. But if someone contacts us and they're being subjected to this behavior, we will act to try to get them into the hands of someone who can provide that emergency assistance. And so we make the commitment to try to develop those kinds of resources and to get people placed where they can get immediate help.
Yeah. Similarly, I think it starts with getting in touch right away, knowing that there are people out at Maryland Legal Aid, and we have fellow legal services organizations here in Maryland who can help. You can find us at www.mdlab.org. Please do get in touch. You can walk in, you can call us, you can go online. It starts there. We need to hear from you. We need to understand what the issue is to see if we can get injunctive relief. We know that we have an affordable housing crisis here in Maryland, so it's very difficult. I think that's the vulnerability that the Attorney General was speaking about today, is that these are often housing of last resort, nowhere to go, and that's what keeps women in these terrible predatory situations. But when we hear about it, we can help take action and see what can we do to help those women and other people experiencing discrimination. So the first step is contacting us so that we can work with you to try and find other options and get you safe.
Any of these cases, could that lead to criminal referrals? And I have a follow-up in a related matter.
So certainly that could lead to criminal referrals. There's no doubt about that. State's attorneys can bring action. You may know that this year the General Assembly passed legislation that will that took effect after certainly what we're currently alleging in our complaint, but has criminalized that conduct at the state level. So the answer to your question is yes. And today we're announcing a civil action against defendants.
And if my follow-up is related to this, how difficult is it to prove? I mean, you mentioned pattern and practice. Do you need anything beyond that?
Maybe Rashida Ogletree George, who's the deputy in civil rights.
Sure. Good morning. To allege a pattern or practice of discrimination, we need evidence from witnesses that they were subjected to pervasive sexual harassment. We believe that we have that. We would also seek documents and additional information through the litigation process.
I was wondering, this Sessoms, do we know if he's married, has children, or what his disposition is now?
Anybody want to speak to that?
That is not information that's in our complaint, and we can't go beyond the facts of our complaint to protect the integrity of the litigation process and to protect the privacy of the witnesses.
Was he the only person with the LLC that we have allegations against, or was there anyone else in that?
He is the resident agent of the LLC, so he is responsible for advertising properties, selecting tenants, setting lease terms. He is responsible for the daily management of the LLC.
And it was one brave woman who came forward to sort of broke this open?
In our complaint, we described 5 witnesses and their accounts of what happened during interactions with Eric Sessoms. They're all brave. We can't discuss who came forward first, but they all have similar stories of pervasive sexual harassment, requests for sex in exchange for rent, quid pro quo harassment.
You mentioned you filed this today, or it's just now, you're just now announcing that it's been filed. What will be the status? Kind of take us through the process, and how will justice be served in this case?
Well, in my view, and I'll have others, either Jonathan or Rashida, take you through the process. Justice will be served, certainly when we remove defendant Sessoms from this line of work. Justice will be served when Mount Vernon Group LLC has protocols in place that whoever they employ, whoever they hire, whoever their agents and officers are, not only understand but implement the kinds of rights and protections that tenants that they're providing housing to are safe and secure and free of sexual harassment. That's justice. Justice will be served when we provide the appropriate relief to the victims, survivors in this case. Anyone want to speak in detail on the process?
Sure. So we filed our complaint today. This is the beginning of a lawsuit. And so we're going to engage in litigation. We feel very strongly about the allegations and our ability to prove those allegations. And if necessary, the case will go all the way to trial. It may get resolved along the way, but we are prepared to take it the entire length of the litigation process. Under the Federal Fair Housing Act and under Maryland law, we can seek a broad range of remedies. As the Attorney General said, we can seek a remedy that it prohibits, an injunction that prohibits the landlord from further serving as a landlord or engaging with tenants going forward. We can seek restitution for people who have been harmed by his behavior. We can seek an injunction requiring that Mount Vernon Group engage in training and implement policies, practices, and procedures to ensure this doesn't happen in the future. And we can seek civil remedies. There's civil penalties for his conduct that would be paid to the state.
I saw a $75,000 figure, and I think in the complaint.
Yeah, that's a technicality in terms of pleading. When you file a complaint under Maryland law, if the claim is for more than $75,000, the complaint has to identify that it's for more than $75,000. We believe that the harm that was committed here far exceeds the $75,000 amount, and we will be seeking remedies for the people who have been harmed at a much higher level than is reflected by just a $75,000 amount.
Attorney General, mentioned in terms of criminal penalties, the legislature was passed session passed some legislation. I just wasn't. I wanted to see if you could expand on what you were referring to.
I'm not going to do that here because I don't want to take the ball off of the civil case we're filing,
Sure.
but certainly let's connect you with Jonathan, we can connect you with our criminal division. But I want to make very clear today, we're announcing a civil action against Mr. Sessoms. The question was asked about whether or not he has criminal liability, and we are focusing on a civil action against Mr. Sessoms. During the course of our investigation in a civil matter, and this is true in all civil administrative matters that we bring, when we uncover and discover criminal activity, we refer it to the appropriate authority, which may reside in the OAG or in our partners in the respective state's attorney's office.
Okay, one more question in back.
Does Sessom still have access to these victims while this is going on? It sounds like he at least had a key or some way to access these properties, and I would imagine the fear of retaliation is real, and the person you're suing has a key to your house.
So we are very concerned about the risk of retaliation, and we've seen that, that in our complaint, you'll see that we've alleged that in other contexts, he's engaged in retaliation. We remain in close contact with the women that he has harmed and are prepared to act immediately if he takes any steps that will be injurious towards them. So that is a commitment we've made to do what we can to protect from any further retaliation.
Thank you, everybody.